When renting out a property in Alberta, one of the most common questions I hear from landlords and property managers is about entry. Specifically, when do you actually need to give 24 hours notice before entering a rental property, and when are there exceptions? Under Alberta's Residential Tenancies Act, tenants have the right to privacy and quiet enjoyment of their home. Because of that, the general rule is that landlords and property managers must provide at least 24 hours written notice before entering a rental unit. That notice needs to explain the reason for entry and take place within reasonable hours. However, the Act also recognizes that real life doesn't always allow for advance notice. There are specific situations where entry without 24 hours notice may be permitted, and understanding these exceptions is important for protecting both the property and yourself. One of the clearest exceptions is emergencies. If there is an immediate risk to people or property such as flooding, fire, a gas leak, or a major plumbing issue, entry can happen right away. In these cases, waiting to provide notice could cause further damage or create safety concerns, which is exactly why the law allows immediate access. Another situation where notice isn't required is when the tenant consents to entry at the time it occurs. This consent must be current and specific. It can't be assumed just because the lease allows entry or because the tenant agreed to access in the past. From a best practice standpoint, confirming that consent in writing by text or email is always a good idea. There are also circumstances where a unit appears vacant or unattended for an extended period. The Act allows entry without notice so the landlord can protect the property from damage, deterioration, or safety issues. These situations require extra care because they carry more risk. Entry should be limited, purposeful, and well documented in case it is questioned later. Showings are another area where the strict 24-hour notice rule is more flexible. When showing a property to prospective buyers or tenants, landlords must make reasonable efforts to inform the tenant, but the law recognizes that scheduling isn't always predictable. Even so, showings still need to be reasonable and should not interfere with the tenant's right to quiet enjoyment. It's also important to understand what these exceptions do not allow. They are not a free pass for routine inspections, non-urgent repairs, or repeated access for convenience. Even when notice is not required, entry must always be reasonable in timing, purpose, and frequency. The biggest takeaway for landlords and property managers is this: exceptions should be treated as tools for specific situations, not shortcuts. When you can't give notice, make sure there's a clear reason, limit the entry to what's necessary, and document everything. Acting reasonably and transparently is your strongest protection if your decision is ever reviewed later. If you're unsure whether a particular situation qualifies as an exception, or you want help putting clear entry policies in place for your rental properties, professional guidance can save you time, stress, and potential disputes. Like, comment, and subscribe for more real estate tips and information.